Coming up next, we have business and immigration law updates. As the world turns, there are often significant changes within business transactions, rules, regulations, and legal matters. To keep us abreast with these movements, Mr. Ramesh Khurana from the Khurana Law Firm will take the lead. The Khurana Law Firm is located in Rockville, Maryland. Along with attorney Khurana in dialogue is Dr. Rajesh Mehra. Together, these two professionals will focus on the significance of priority dates for green card. Let's join them.
Good morning. This is Dr. Rajesh Mehra, and I appreciate you tuning us into your homes this morning, and welcome to the Capitol Forum. This forum is designed to bring prominent people in our community of the Metro DC area to talk and educate you from everything from medicine to law, as well as some business features that are going on. This morning, I'm most delighted to have join me again, as in the past, Attorney Khurana. Welcome, sir.
Thank you, Dr. Mehra.
But well, from your last presentation, we had a lot of emails and comments because this is a very hot topic these days. And we're starting a series on immigration law, immigration practice, immigration rules. And we touched on this concept about priority date. Why don't you recap for our audience what you touched on, and then I think I have a few more questions about it.
Sure, Dr. Mehra. It's my pleasure being here this morning. Dr. Mehra, when we talk about the priority date concept, like as I mentioned very briefly, of course, for want of time, we could not finish
Go on and on, right?
Concept, right? So I would like to elaborate on that concept first, as you rightly asked me. The concept of priority date is basically the registration of an application or petition which has been filed by any person for the immigration benefit. So whenever a person, let's say that he's trying to sponsor his parents who are living in India. So he's filing a relative petition, we call it I-130 for his parents. So when this application reaches the USCIS, now USCIS is just an agency of the Department of Homeland Security. So when it reaches USCIS, if the application is properly signed by the applicant and proper fee has been paid along with the application.
Which is what?
It's $420.
Okay.
And if it is found acceptable by the USCIS, they issue a receipt notice that we have received the necessary fee and the application. Along with that, they will indicate the priority date. So this is how that
date gets set.
Yes, the registration date or the priority date gets set. And, you know, like there is a rationing of green card numbers. So whosoever comes first, whosoever stands first in the queue, he gets served.
First come, first served.
First served.
Got
yes.
it. Got it. Now, can one foreign national have more than one qualifying petition, or is just one person, one petition?
A foreign national definitely can have more than one qualifying application. Now, if we are talking about immigration-based petitions, let us say that the foreign national is working with company A. Now, company A has filed a green card petition for the foreign national. Now, he also has an intent to work with probably company B at some point of time. So he approaches company B, and if company B is willing to file another petition for the foreign national, so that could be filed. So practically speaking, a person can have two or three.
More than one.
Or more than one, or I will say multiple applications. So there's absolutely no problem.
But does that really increase the chance of getting through the system quicker, or it's just like buying 10 lottery tickets? You know what I mean?
Yeah, I know.
Some of us buy 10 lottery tickets, some buy one. But does it, in the big schema, increase your chance of getting the lottery?
Dr. Mehra, there could be two possibilities when a person would like to file, let us say, two applications. Now, there are different preference categories. And for those different preference categories, there is a separate queue. Now, let us say a person has filed a petition for EB2. Now, EB2, which is basically for master degree or advanced degree holders, the queue moves much faster. As we talked during our last segment, and priority dates have really been becoming correct. Yes.
Right.
Now, a person who had, let's say, just bachelor degree, he didn't have 5 years of experience. Over a period of time, now he accumulates work experience. Let's say it's more than 5 years. So bachelor degree plus 5 years of work experience would make him eligible to file under EB2 category. So he can approach another employer to file a different petitions for EB2 category. So then, of course, the question asked was whether it really speeds
Increases
up.
The
yes,
chance.
it does speed up because he has moved from EB3 category to EB2.
EB2.
Yeah.
Got it. Now, as far as the priority date, how does it work when you're talking about a spouse or a child into this whole thing?
When we are talking about a spouse or child, so this is covered under family-based visa bulletin. So when the priority date becomes current for the parents or parent, depending upon whatever is the case, so it becomes current for the child simultaneously. But the caveat is, if the child turns over 21, then there is a problem.
Okay.
Then there are different set of regulations.
Rules.
Yeah, you know, we have a Child Status Protection Act, but it needs to be understood. But we can say that when the child turns over 21, because he's no longer dependent upon his parents, and most of the times he gets deprived of the benefit of the petition or the application.
Well, again, I'm just totally flabbergasted at the complexity. I never realized that it was so complex, but we appreciate you sharing that with us, and we look forward to having you again next time to talk about some very more interesting topics on immigration and business law.
Thank you
sir.
very much, Dr. Mehra, for having me here in your studios.
Thank you.
It's always a great pleasure.